Request for evidentiary hearing. Mr. Carnes, I know you've responded to that and you have the burden of proof. So I'll turn it over to you.
Your Honor, I would ask today for the court to deny defendant's motion because the defendant has not stated any facts that would support a finding that defendant has standing to assert any Fourth Amendment rights to this truck. There's no allegations that any personal backpacks or anything were in the truck and searched, and the truck was abandoned. The whole reason we're here setting for trial is that defendant is claiming he was not operating the vehicle. I think just based on these, the facts alleged in the motion, there's not a making out that the defendant has standing, and that is the defense's burden of proof. As stated in People v. Body, the defendant does have the burden to establish standing in order to challenge the search and seizure violating the Fourth Amendment. Here he has no Fourth Amendment standing. So based on that, I would ask the court to deny defendant's motion. And if the court finds that somehow there is evidence of standing, then I would ask the court to set this out for an evidentiary hearing.
I thought that's what we were here for today, was an evidentiary hearing.
I was not aware of that. I considered, since it was fit with the court scheduling, we had 15 minutes to hear this. I know sometimes, other times when there's no motion, I have been allowed to accept for it. That's what I was planning on today, but again, I don't think we get any evidence.
Is O'Mara?
Well, I'll address standing first, I suppose. I believe that the prosecution is inherently arguing based on the charge that defendant was driving as they allege, and it's just an element of the crime they prove beyond a reason doubt. Then I feel like my reliance on that as their justification for the search, and my reliance on that as justification for the standing without admitting to anything, is where standing would come from. If they're going to argue that there's not evidence that he had any possession of the vehicle, then how can they be arguing that he was driving with his license suspended? You know, I don't think that they can have that both ways when it comes to standing.
What is it? So I wasn't necessarily clear from your motion what it is that you're trying to suppress.
I was attempting to suppress the search of the vehicle.
The entire search?
The entire search.
And was there anything discovered during that search?
There were allegedly lottery tickets discovered in part of the car that the prosecution claims is evidence of who was sitting where in the car.
And how are the lottery tickets tied back to your client? I assume that's what you're trying to suppress. So how is that tied back to your client?
The lottery tickets are alleged to be tied back to the other passenger of the car, who claimed that, and the prosecution is claiming that because they were found in the passenger side of the car, that would be where the other person had been sitting. And there were other things found, but I believe that's the only thing mentioned in his response.
So now I'll turn back to you, Mr. Carnes. In order to determine standing, don't I need to take some testimony to determine what police knew, how they knew it, what was said, what wasn't said, who saw who where?
Since I saw that standing is a burden placed on the defense, I assume that the court could make a finding as to that without any evidence. The whole reason why this is being set towards trial is defendant denied operating In which case, that's an abandoned vehicle. There's no report of that.
It's 5 feet away from the car.
When law enforcement was there?
Yeah, he didn't, I wouldn't classify it as abandoning the vehicle. He allegedly been in an accident and simply left the vehicle. I don't think that's the same as abandoning the vehicle.
Oh,
And he also was receiving medical care, or needed medical care. Obviously, there were no EMS on site at that point.
so Mr. Carnes, what makes you think that he had abandoned the vehicle?
He denied operating it.
Was he the only one on scene?
And he denied ownership of it as well.
Was he the only one on scene?
Yes, he was. The other party had walked away. Was caught up with later.
So what were police investigating?
Car accident.
So like a failed to report?
Well, it was, yes, although that was not charged, but the blue truck hit a parked minivan. The owners of the minivan came out, and other neighbors came out, and police arrived.
And so when law enforcement arrived, what were they investigating?
They're investigating a traffic accident.
Not a failed report, but a traffic
You
accident.
know, Your Honor, the more I think about it, I don't think enough time elapsed to say it was a failed report, because law enforcement was on scene so quickly. I would guess it was minutes based on the location of the other passenger who seemed to be walking away as quickly as she could.
So they were called just to investigate a traffic accident. Had anybody talked to Mr. Porter prior to them going into the vehicle to search it?
Yes,
Who?
the
Talked.
Officer Howell stayed on scene and talked to Mr. Porter while Sergeant Izzard pursued the passenger who was walking away.
So I might add very briefly, before he starts searching the car, it's maybe 15, 20 seconds. It was on scene.
Long enough to elicit responses that he was not driving the vehicle, and the vehicle did not belong to.
So now, Ms. O'Mara, I'll turn back to you. If he denied ownership of the vehicle, how does he have a privacy interest in the vehicle?
Well, I mean, passengers do have a limited privacy right to a vehicle. And the person we're alleging is the driver would still have the privacy right to said vehicle, even if they aren't on the scene. And they did search the passenger side of the vehicle first, to be fair.
And see, this is all stuff this is stuff I have to have an evidentiary hearing on. I mean, it's not that I can't take you guys at what you say, but I have to have the officers here to testify as to what they spoke to, because really the question is, and I understand your argument regarding standing, but the question is, I have to view this in the totality of the circumstances. Did police have reasonable suspicion or reasonable grounds to go in and search that vehicle based on the totality of the circumstances? Now, one thing, so what I'm going to do is I'm going to adjourn today, and I know we're set for trial on this, and jury notices have to go out, so therefore I've got to adjourn the trial because jury notices would have to go out today. But I think both parties should probably take a look at, because I'm going to bring this up during arguments, is People versus Langley, 113 Mishap 567. It's an older case. It's probably older to you guys, not as old to me, but it's from 1982. And it wasn't appealed, and as far as near as I can tell, it's still good law. So the party should take a look at that and be prepared to argue that next time we're here. When can we get this back on the books? Next
We can
Friday.
Get everyone here, we can try to do it.
I'm out next Friday. Yeah.
So. let's see. We can add it on that afternoon of Monday, October 6th, after the motion.
After the motion.
We could do it at 2:30.
All right. We know everybody's available on October 6th, so we'll reset it for October 6th. And I think in order to determine whether or not they're standing, I have to hear the totality of the circumstances to determine whether they're standing to challenge it. Because Ms. O'Mara is right. We all know Mead tells us that even though there's a passenger, it's a passenger, there's some expectation of privacy. But Mr. Carnes is also correct. If this is truly an abandoned vehicle, there might not be as much expectation of privacy. However, I need to see the totality of the circumstances to make that determination.
And that was October 6th at what time?
2:30.
At 2:30. Thank you.
Judge,
Yes.
do you want the motion on the 6th, and then do you want to use that October jury date as the potential date,
Potential date for what?
jury trial?
No, because you won't have enough time to get the notices out.
Oh, duh.
And
If
if I suppress anything, I don't want to have a
So
trial.
we'll
Okay.
wait to hold off. Okay.
Okay.
I would, for what it's worth, the people would be ready to proceed to trial, even if the motion is granted in full. It would weaken my case somewhat, but not that much.
You might be ready for it, but I don't want to prejudice the defense
Okay.
at all, if that impacted their trial strategy at all. And that would only give us
Or we could do the 31st.
Yeah.
just a
Yeah,
couple
we-
days, right?
Yeah,
Because we were set for a 7th. No,
because 17th,
17th.
so that would give us a week and not a full 2 weeks.
but we've already got trial set for the 17th.
Yes, we do.
Yeah.
We have a trial set for the 17th and the 31st.
All right. So what we'll do is we'll handle the motion to suppress. I'll adjourn the trial. We'll see where that gets us. And then we'll check if the case still stands after that, we'll set a trial date after that.